Imagine this. You've just lost your job, and the difference between getting 6 weeks more wages or 6 months more wages could turn on 5 or 6 words. In almost every wrongful dismissal case that I deal with, whether for an employer or a dismissed employee, the wording of the termination provisions in the employment contract is critical. Many employers try to limit the employee's entitlements to what's provided for in the Employment Standards Act, which is, for the most part, a lot less generous than what the common law provides for. Notice periods counted in weeks rather than months. Over and over in recent years, the Ontario courts have been finding termination clauses to be unenforceable because they either directly violate or have the potential to violate the Employment Standards Act. To give a recent example, in the Dufault and Corporation of Township of Ignace case in 2024, the court determined that the use of the words "at any time" in a clause about termination without cause was inconsistent with the Employment Standards Act because there are some narrow circumstances when an employer can't terminate an employee's employment. That case was upheld on appeal, but the Court of Appeal did not specifically address that point. Now comes the Bertsch and Data Stealth case. Court of Appeal decision released earlier this year, which upheld a lower court's ruling that a termination clause restricting the employee's entitlements to the ESA minimums was valid and enforced it. I expect to see a lot of employment contracts redrafted to use the exact language from the Data Stealth case, with the comfort that this language has been given the stamp of approval by the highest court in Ontario. Now, just to keep things interesting, in February of this year, in Baker and Van Dolder's Home Team Inc., the Superior Court ruled that a termination clause was unenforceable, essentially because employees can't be expected to know what the Employment Standards Act provides for. The court relied on an earlier Court of Appeal decision, Rossman and Canadian Solar, that ruled that employees need to know the conditions, including entitlements, of their employment with certainty. So let's look at the wording of the termination clause in Data Stealth. Termination of employment by the company. If your employment is terminated with or without cause, you will be provided with only the minimum payments and entitlements, if any, owed to you under the Employment Standards Act and its regulations, as may be amended from time to time. You can read the rest of the termination clause, but essentially it just points to the Employment Standards Act. The Court of Appeal found all this to be enforceable and acceptable, even though it essentially left it to the employee to know what the Employment Standards Act provides for. The Baker decision is being appealed, so maybe by the end of this year, we will have some more new law to keep employment lawyers on their toes.